Hello everyone. Today we are going to discuss on the title of Establishment of High Courts in India. Well, I am Dr. Sharmila Guge and I am going to discuss about this module, and the objectives of this module are to learn more about the historical perspective of establishment of high courts in India, to understand the role of high courts, appointment of judges and the jurisprudential approach of high courts. Well, to begin with the establishments of high courts in India, we first take a glance at the introduction for this particular topic. The history of establishment of high courts in India evidences back to the phase of British rule. In the year 1600, the Britishers came to India as traders and established in East India Company, but rapidly captured the Indian provinces, as a result of which the British laid their hands deep in the administration various provinces. The indirect rule of the company came to an end in 1857 with the First World War of Independence. The British began their official rule with the Government of India Act 1858. Thereafter, by the recommendation of the Second Law Commission, the Indian High Courts 1861 Act was passed. Before the commencement of the Act, a double system of administration of justice prevailed in India. On the one hand, there were British Crown courts and on the other hand, the company courts. The British Crown established the Supreme Courts in the presidency towns of Madras, Bombay and Calcutta. The Indian High Courts Act 1861 suggested the establishment of high courts. The company courts were Mufuzil courts and Diwani Adalat. This created many problems as the jurisdiction of the company courts and the Supreme Court were not clearly demarcated. The charter of the High Court of Calcutta was ordered in May 1862 and that of Madras was ordered in June 1862. Well, the order for the Bombay court was also in the year 1862. Bombay was the first place in India where British justice was administered to local inhabitants by a British court. The British government therefore decided to abolish and then existing Supreme Courts and Sardar Adalat and replaced it with the High Courts. These High Courts had the distinction of being the highest courts for all cases till the creation of the Federal Courts of India under the Government of India Act 1935. Now, let us take a glance prior to the Constitution. What was the situation of the High Courts? Well, as we just mentioned, the High Courts Act enacted in the year 1861. This act was a short legislation having only 19 sections, 19 sections, and authorized the Queen of England to establish High Courts by issuing letters patent to presidency towns as she deemed fit. Accordingly, the first High Court in British India was the High Court of Judicature at Fort William, also known as High Court of Calcutta. This High Court was established by the letters patent dated 14th of May 1862, issued under the Indian High Courts Act 1861. Similarly, the charters of the Bombay and Madras High Courts were ordered in June 1862, having identical powers and jurisdiction. Each High Court consisted of a Chief Justice and other puisne judges not exceeding 15 in number. Well, now let us take a glance at the qualification to be a judge under this Act. A person could be appointed as a judge of a High Court if he or she were either 1. A barrister of not less than 5 years of standing, 2nd. A member of the coveted civil service of at least 10 years experience standing, who had served as Zilla judge or at least 3 years in the period, or a person having held judicial office not inferior to that of principal admin, or a judge of a small cause court for a period of at least 5 years. A person who had been a pleader or Sardar court for at least 10 years. At least 1/3 of the judges of a High Court, including Chief Justice, had to be barristers and the other 1/3 judges had to be members of civil services. the judges held office during the pleasure of the Queen. She could give them power to exercise all civil, criminal, admiralty and vice admiralty, testamentary, interstate and matrimonial jurisdiction. Having said that, let us now understand what was the jurisdiction of the High Courts in the British era. Well, High Court was also functioned as a court of record and had power of superintendence over all the subordinate courts. The High Courts had a power to exercise original jurisdiction and extraordinary jurisdiction to try offences committed by persons residing within the local limits of any court it had superintendence over. The High Court could decide suits that dealt with subject matters of dispute, but were valued at not less than ₹100, as such matters were to be adjudicated by the small causes courts. The High Courts also had appellate jurisdiction over criminal and civil cases adjudicated by the courts subsequent to it. It also had power to enroll and admit advocates and vakils, and was empowered to determine necessary qualifications for pleaders, advocates and vakils. However, in civil matters, an appeal would go to the Privy Council against a decision of the High Court if the value of the subject matter in dispute involved or exceeded ₹10,000, or if the High Court certified the case as one fit for appeal to the Privy Council. In addition to this, appellate provision, an appeal would lie from Privy Council against the decision or order made by the High Court while exercising its original jurisdiction. Now, let us move on further to the position which we had in India in the year 1915. Well, Government of India Act 1915 and the subsequent changes have an importance in this topic. After 1861, several other high courts were established in the British India. A high court was established in Agra on March 17, 1868, which was later shifted to Allahabad in 1875. With the passage of time and functioning of high courts, it was realized that the number of judges needs to be increased. In view of the same, the Indian High Courts Act 1911 was passed, which increased the number of judges in the High Court was 15 to 20 judges. The Act also authorized the establishment of more High Courts wherever and whenever it was deemed fit. It also empowered the Governor General in Council to appoint additional judges to other High Courts for a period of 2 years. On July 27, 1915, the British Parliament passed the Government of India Act 1915. This Act repealed the earlier provisions and brought in several changes regarding the composition, jurisdiction of the High Courts. The Act restricted the jurisdiction of the High Courts of Calcutta, Madras, Bombay regarding the exercise of powers in revenue matters. All High Courts were to remain courts of record and had the power of superintendence over all courts subject to their appellate jurisdiction. High Courts also had the power to frame rules and regulations penetrating the subordinate courts' functioning. Well, now with this we move ahead to the Government of India Act 1935, which indeed brought significant changes. The enactment of Government of India Act was a foundational stone not only in the Indian independence but for the much required changes in the country. This Act repealed several earlier enactments. As per this Act, every High Court consisted of Chief Justice, the Governor General in Council, was authorized to appoint judges of the High Court and was also empowered to appoint additional judges. These judges were to hold office until they attained the age of 60 years. A judge of a High Court could be removed from his post on grounds of incapacity of mind or body or misbehavior only on the recommendation of the Privy Council. The said Act allowed even Indian judges with 3 years experience to be appointed as Chief Justice against the earlier rule of appointing only English barristers. The salaries and pensions of the judges were fixed by the King. This particular part of this module is indeed important, because if you have realized, it is mentioned that even Indians were appointed as judges. Otherwise, prior to this, only English people were appointed as judges. Moving ahead, the pre-constitutional writ jurisdiction of the high courts. Well, today as we all study the writ jurisdiction under the present constitution, we also need to understand what was the basic situation historically. Before the enactment of the Constitution of India, all high courts had the power to issue the writ of habeas corpus throughout the territories falling under their original and appellate jurisdiction. Well, the high courts of Calcutta, Madras, Bombay had the power to issue other writs as well. Regarding the changes in the judicial system, Lord Macaulay has expressed that, quote, "We are trying to make brick without straw, to bring a clean thing out of an unclean, to give a good government to a people to whom we cannot give a free government," unquote. Initially, justice was dispensed in the rudimentary manner by untrained judges who held a dual role as senior officers of the East India Company. As the British sovereign replaced the company, the courts were liberated from the company's narrow goals. They focused on resolving disputes and striving to establish the rule of law, albeit within the framework outlined by Macaulay. The struggle to check the executive power was challenging. Although sovereign acts of the state were deemed beyond the court's jurisdiction, those carried out under municipal laws became subject to judicial review. The passage of the Specific Relief Act in 1877 acknowledged thorough statute the court's authority to issue writs similar to those from the King's Court. Insights from England empowered the high courts to oversee the executive, yet this authority was limited geographically. Now let us analyze the situation after constitution, which we call as the post-constitutional phase. Well, the constitution not only preserved the existing authority of the high courts, but also eliminated imposed restrictions. The exclusive power of high court with original jurisdiction to issue writs was extended to every high court. Derived from the constitution, statutory limitations could no longer constrain this authority. Well, Article 226 broadened the power from issuing prerogative writs to encompass any other directions, orders or writs. High courts could now devise and grant reliefs that their predecessors could not. Acting as a constitutional sentinels, the power of the high courts remains unimpeded except for instances of self-restraint. Over the past 7 decades, numerous high courts have been dissolved and established. Former high courts like Audh, Nagpur, Patiala and East Sindh States Union and Mysore no longer exist. The geographical regions they once governed are now under the jurisdiction of other high courts. Simultaneously, new high courts have been created for regions previously under the jurisdiction of other high courts, with the original high courts persisting and exercising authority over different geographic areas. For instance, the Delhi High Court was established in the year 1966. After independence, the region of Delhi fell under the jurisdiction of former High Court of Punjab. The High Court of Delhi also held jurisdiction over Himachal Pradesh until 1971. Following the creation of Himachal Pradesh as a separate state, the jurisdiction was transferred from High Court to Delhi to newly formed High Courts of Himachal Pradesh. Well, now let us understand the criteria for appointment of judges and the composition of high courts in our country. High Court constitution during the British era, and each high court consisted of Chief Justice and a maximum of 15 other puisne judges. However, significant alterations were made to the composition of the Indian high courts later on. Every high court shall now have a Chief Justice appointed by the President. Unlike the previous practice, there is no number fixed of judges who can be appointed by each High Court. It means that any High Court will have number of judges as required in that particular territory. Additional judges can be appointed to expedite the resolution of pending matters in the court. However, their tenure cannot surpass 2 years. Moving ahead, Article 217 of the Indian Constitution delineates the procedure for appointment of judges to a High Court. As per this particular provision, the President, in consultation with the Chief Justice of India and the Governor of the state, is tasked with the appointment of judges. If the appointment pertains to a judge other than the Chief Justice, the Chief Justice of that particular High Court is involved in the consultation process. Moving ahead towards the appointment of Chief Justice of the High Court. We have just discussed the appointment of judges of the High Court, and now we are moving ahead with the Chief Justice appointment. Well, the government, in consultation with the Chief Justice of India, has formulated a policy mandating the appointment of Chief Justices for all High Courts from outside. The elevation of puisne judges to Chief Justices is based on inter-seniority within their High Courts. Judges with 1 year or less than retirement may be considered for Chief Justice if a vacancy arises during that period. The Chief Justice of India initiates proposals for High Court Chief Justice appointments, consulting with 2 senior-most Supreme Court judges. Once approved, the Department of Justice announces and notifies the appointment in the Gazette of India, ensuring completion at least 1 month before the anticipated vacancy. Well, have there been any attempts to reform the situation and the provision? Yes, attempts of reform have been made. In the year 2014, an attempt was made to replace the collegium with the National Judicial Appointments Commission, commonly known as the NJAC. Through the 99th Constitutional Amendment Act 2014, the NJAC aimed to bring greater transparency to the appointment of High Court and Supreme Court judges, including Chief Justices, by having commission composed of members from the judiciary, legislature and civil society to oversee the selection process. However, in 2015, the Supreme Court's constitutional bench declared the NJAC unconstitutional. The court argued that it violated the basic structure of the Constitution of India, expressing concern about its potential to undermine the independence of judiciary. Well, the sentinel duties of the judiciary are to be discussed, and what are those duties? The duties begin with being a guardian of the Indian Constitution, ensuring rule of law, safeguarding the rights, exercising these powers within the jurisdictions conferred on them. Moving ahead, is that the case that we are all happy with what the situation is? Never. There is always a possibility of having reforms, and there is always a factual situation of having challenges to the present situation. Thus, let us take a glance at the challenges and the reforms we have. High courts face various challenges, one of which is the non-availability of a comprehensive set of scientific data that hinders in-depth and meaningful analysis of pending cases. This observation has been emphasized multiple times by the Law Commission of India in its 245th report, titled as Arrears and Backlogs, Creating Additional Judicial Manpower. The data from the High Courts is marred by errors that makes substantial portions unusable in its current form. To analyze this data, a thorough checking and cleanup process is necessary, which is impeded by the substantial volume of data and the numerous mistakes it contains. In terms of data, each High Court operates as an isolated entity. Every High Court website has its own site layout, data formats and varying extents of data availability. This lack of data standardization poses a challenge, as logically case related information should adhere to uniform standards. Additionally, data management proves to be a significant issue. The major challenge faced by high courts is the pendency of the matters due to less number of judges and vacancy in all high courts in India. There is immediate need to appoint more judges for filling up the vacant positions. Similarly, there is need to develop the infrastructure and strengthen the computerization and virtual court system. Having said that, let us now conclude this particular module. Well, the establishment and evolution of high courts in India reflect a dynamic journey from the constraints of colonial rule to the expansive powers bestowed upon them by the post-independence constitution. The constitution not only preserved the inherent authority of high courts, but also eliminated previous limitations, granting them jurisdiction beyond their original boundaries. Over the past 7 decades, shift in geopolitical structure have resulted in the dissolution and creation of high courts, aligning their jurisdiction with administrative requirements. The appointment and composition of judges in high courts underwent significant transformations, emphasizing the roles of the President, Chief Justice of India and other consultative processes. The 2014 attempt to reform the appointment processes through the National Judicial Appointment Commission, commonly known as the NJAC, faced constitutional challenges, ultimately being declared unconstitutional by the Supreme Court in the year 2015. High courts serve as constitutional sentinels, wielding powers of judicial review, safeguarding fundamental rights and upholding the rule of law. The expanded powers under Article 226 empower high courts to address a diverse range of matters, positioning them as the primary recourse for litigations. However, persistent challenges include issues of data standardization, errors in the court records and the imperative need for enhanced scientific data availability for comprehensive analysis. Moreover, this epoch of digital globalization is characterized with various transformations and e-courts is one such progression. In the contemporary era, the technological developments and scientific innovations have transformed human lives and the work culture comprehensively. Indian courts and justice systems are not an exception to the revolutionized developments. It can be said that the use of technology for justice system is not just then sanctification for the nation. In accordance of the set significance of e-courts, the Indian government has made its strides to establish India as digitally empowered nation. Adopting technology in courts in form of e-courts has opened a floodgate of innovations coupled with opportunities. However, all high courts and lower courts need improvised infrastructure for better functioning. In the face of these challenges, it is imperative for high courts to adopt continually streamline processes and embrace reforms to enhance efficiency, transparency and accessibility. High courts stand as indispensable pillars in upholding the constitutional framework and delivering justice to the citizens in India. The journey of high courts, marked by resilience and evolution, underscores their critical role in the nation's judicial system. As they navigate the complexities of modern legal landscapes, high court must remain vigilant, ensuring their adaptability to meet the evolving needs of justice administration in India. And in doing so, they contribute to the broader narrative of a robust, responsive and equitable legal system for the nation. With this, we end our discussion of this particular module over here. Thank you very much.